So morning all. I'm the act on before lunch, so I'll see how we can get through this. Not such a dry subject, quite an exciting one, depending on the way you look at it. But the aim of the talk today is to give you a very high level, and I mean a very high level view and introduction to GDPR. Much of what we discuss can be broken down into a number of very detailed subtopics. So this will be a very high level whistle-stop tour of what is 99 articles, several chapters, and a lot of detail. By the end of it, however, I hope that you'll have a better understanding of GDPR, its core principles, the enormity of what is actually coming next year, and the importance of being prepared when this becomes legislation in May. I myself have spent the last 5 to 6 years studying what is now known as GDPR, and in fact have changed my complete career process during this time. My background was a technology specialist. I was one of the key crew that implemented BBC iPlayer for the BBC many years ago. Now, I'm a fourth year undergraduate lawyer with the OU. I will qualify next year, and I will specialise in data protection, privacy, but also child protection, which is an added bonus for me. The general data protection, this GDPR, it will build on the current Data Protection Act of 1998, but it will build on it in a very specific and onerous way. It has taken, the purpose of it is to provide more protection for customers and consumers, so you as members of the public. It gives more privacy and consideration for organisations, so organisations are going to have to be a little bit more prepared about how they treat our personal information as they move forward. It brings us up to date with the approach of how the rest of the world is actually dealing with data protection outside the UK. The EU already starts to develop some different services before GDPR came along. It gives us specifically new obligations, new challenges for the organisations around reporting data breaches, around transferring data across borders, and around how you introduce information and data into your business. And a lot of the processes and procedures that are coming in will be mandatory, as in the old or the current Data Protection Act. What comes in GDPR will be mandatory. You will have no choice but to implement what is coming. Consumers and citizens, they will have a stronger right to be informed how organisations use their personal information. They will have the right to request personal data to be deleted, removed, amended, and especially if there's no compelling reason for you to keep their information on your databases. It's going to put even more responsibility on organisations to understand and respect the personal privacy of our personal data. At the centre of GDPR is the concept of a broader and deeper accountability for organisations who handle our information. It brings into the UK law a trend which we've seen growing in a number of parts of the world, as I've said. The demand for organisations to understand the data they're holding, to mitigate it, look after it, and present it clearly and properly. It's about a framework that should be used to build cultural privacy and that pervades on the entire organisation. So it affects everybody in every organisation in every way who remotely stores information about individuals as a whole. It goes back to the idea that being more than a technician. So although we have cybersecurity, we have firewalls and all the other boxes and wires that you can talk about around your information, this is not about the cyber side of it. This is about data protection. Business data protection and protection of your personal information. So, let's move on. So I'm going to give you a very brief overview of where we are. So as I said, GDPR is not a directive, it is a regulation. The difference between the two, directives that are implemented within the United Kingdom the EU gives a degree of flexibility of how that directive is implemented. So it may not need to be implemented in its entirety. It's implemented in the best way that suits the country it's being implemented in. A regulation does not do that. A regulation will be a piece of legislation as though it went through Parliament, went through all the readings that it would do, and went through royal assent, such as the current Brexit policy that has just gone through. Because of that, you will be breaking the law if you do not comply with this legislation. It's no different to you being charged £200 for using your mobile phone in a car. You can't say I forgot, you can't say I didn't remember, you will be fined and you will have 6 points on your licence. It's no different. GDPR comes in on the it says May 2018. If you look at the ICO's website, it says the 25th of May. That gives you less than 11 months. If you take summer holidays, Christmas, Easter, and other bits and pieces that happen to us in the UK, that doesn't leave you a lot of time. And it will replace the current Data Protection Act of 1998. The government has confirmed, I think they confirmed in January of this year, that despite Brexit, the UK will be adopting GDPR. Bearing in mind they've spent with the EU about 5 or 6 years developing this, it's pretty unlikely they're going to go and make their own Data Protection Act outside of this. So be clear, Brexit or no Brexit, this is coming. The GDPR applies to controllers and processors, and there's a difference between the two. Oh, sorry, let me go back one. A controller is a person or a company that is responsible for the information that it is holding. A processor is responsible for processing that information. The relationship between the two is one to many. So within organizations, you have data controllers who manage your data. And you may use processors outside your company to process data. There are huge implications with processors and controllers within GDPR. If you're a controller, you will have an onerous amount of obligations put upon you to ensure that you comply with GDPR. You will be where the buck stops in relation to the core principles of what GDPR is trying to achieve. If you're a processor, you also have obligations. You have obligations to ensure that anything that is processed, deleted, changed, managed is fully documented and is fully trackable in the event of a breach or in the event of the ICO coming and doing an audit. Are you scared yet? This is just the first slide. Where are we? The GDPR applies to data processing carried out inside the EU, which we still are, and outside the EU. However, if data is being processed outside the EU and there is no agreement between the EU, the United Kingdom, and the country that's being processed in, then you will have to find a data processor that sits within the EU to process your data. You are also responsible legally to ensure that the data processors that you employ or use comply with GDPR. I was speaking to a lady earlier this morning, just before this session took place. Contractually, you can write into contracts that they will be liable in case of a breach. That is not the case. You will be liable if there is a breach. You can sue the other party without a problem, but the ICO will hold you responsible as a controller of that information to ensure that your processes are compliant and breaches are not happening, and you are carrying out regular audits to ensure that's not happening. As it says up there, this will not apply to law enforcement or any governmental agency which requires information for a legal law enforcement perspective. GDPR under Article 8 complies with the European Convention on Human Rights. It's the right to respect for privacy and family life. So one of its core values does ensure that it complies with the European Convention, and it will also probably, therefore, comply with the Human Rights Act within the UK as well. Here's the nice one, a breach. So, a breach of any magnitude will cost you 4% of your gross annual turnover of your business, your company, that's worldwide, or 20 million euro, whichever is the greater. Now, an example, Tesco Bank had a major breach. If they were subject to GDPR, and if GDPR was in legislation now, can anybody guess what the potential fine was going to be for Tesco Bank? 100,000 records? 1.9 billion would have been the fine had this been in place. So it just gives you a bit of, I don't know, makes you think a bit more. GDPR does have principles. I'm asked a lot about, there's a lot of stuff, and there is a lot of stuff, but it doesn't mean anything. How do we do it? How do we implement it? It doesn't actually say what we've got to do. Well, it's actually based on international standards, based on International Standard Organization, and also based on the International Electrotechnical Commission, based out of France, with the standards that a lot of you probably know these numbers, don't really know what they mean maybe, but they are based on standards. GDPR is based on international standards that already operate. ISO 27001, you may comply with that already. As a business, you carry out the operational piece of that. You may not be registered or certified with that because that's a costly thing to do, but you may follow its principles. GDPR follows these principles. So, the information, what does GDPR apply to? Personal data, sensitive data, and pseudonymous data. Personal data. I won't go and read an entire paragraph. Suffice to say that it's data relating to a living person. And the sort of data it looks for is your name, your address, your financial details, any cookies you may have stored on your computer, CCTV footage, video footage, your IP address if it's a non-static, your medical information, telephone number. Anything that pertains to who you are as a person is classified as personal information, including biographical, biological information. That's then broken down into sensitive personal information. And what I mean by that are things like your ethnic origin, your racial origin, political opinion, your religious beliefs, memberships of a trade union, physical or mental health details, your personal life, anything pertaining to your personal life that sits outside the information given as a name, address, phone number, email address. Any criminal or civil convictions. This is sensitive information. This already exists within the Data Protection Act, but it goes on a little bit further because it now takes into account genetic data and biometric data. So, pseudonymous data, this is an interesting one. I'll give you an example of pseudonymous data. There's a marketing campaign going on, all bald men with glasses wearing tattoos love shampoo. I don't know why they love shampoo, but that's what I came up with on the train this morning. So, it's absolutely anonymous. Nobody can tie my name, my address, any unique identifier to me whatsoever. In the event that they can do that, you've breached the data protection. So the concept of pseudonymous data is that it's data that is used without any indication of who that person is, that the research or the marketing campaign, even recruitment is being done on. It does not identify you in any shape or form. You don't exist as a person, you are just a statistic within that. Okay, so this is a long one. The first thing, clear and affirmative consent. You need to demonstrate that whenever you get consensual acceptance from an individual to use their information for anything you want to use it for, you have their consent. And it's not good enough you doing it on the telephone. It's not good enough you putting an email together that says, I've got consent. You will have to demonstrate it, document it, you need to keep a record of it. Time, date, place. If you have a website where you ask people's information to tick a box, it can't be a small box. It's got to be very clear and concise, to a point where a person can't ring up and say, well, I didn't understand that, and you're using my data, and I don't want you to use it. So again, when you look at what you will have to start looking at doing, it takes into account not just your day-to-day business, it also takes into account what you're doing with that business. Children. It's one I've put in. I don't know if any of you that may have child records for any purpose, but I'm talk a little bit about children and the measures that you'll need to put in place with regards to children. There are a handful of child-specific provisions within GDPR, particularly relating to the processing of child information. And children are identified as vulnerable individuals, as you would expect, and they deserve specific protection because of that. The processing of data can carry risks, and it can be, and again, there's a huge fine attached to even breaching anything where children are concerned. However, the GDPR does not indicate what is defined or classified as a child. In the United States, a child is classified as the age of under 13. So it requires parental consent up until that age. At the age of 13 in the United States, in relation to websites, Facebook, and so on, children are considered able to make their own decisions. I'm not saying they don't need their support their family, but it is written in law in the US that it's under the age of 13. That's about what I'm going to say about children. It's a difficult one. At any time, if any of you deal with children or processing children's information, you will always best require the parental consent, because it's so ambiguous within GDPR as to what age is an adult, up to even to the age of 16. My suggestion would be to ensure that you always get parental consent up until the age of 18. The right to be forgotten, also known as the right to erasure. We've all heard of the Google right to be forgotten. It's no different to that. I don't need to go into great detail about it. People have the right to be forgotten. Anybody at any time has the right to contact you and to ask you to remove them completely from your databases and to show you that you have done so. So not just to do it, you need to demonstrate you've done it clearly, again, in writing. Individuals will have the right to know when their data has been hacked. If you have a breach, you have 72 hours in which to report it to the ICO. If you fail to do so, you'll be fined. And the ICO will want a complete written record of why you failed to tell them within 72 hours that you failed to disclose the breach. As an individual, I have the right to know about the hack, and you have an obligation to tell me about that hack. As I said, plain language, we go back to the websites, we go back to how you will capture people's information. Again, you cannot be ambiguous, there must be transparency, the language must be simple to a point that anybody can understand. So you are working to the lowest common denominator, not the highest. We've talked about fines. I'm just adding that as highlighting it one more time, but it is one of the key provisions. Data Protection Officer. There is nowhere in the GDPR that makes it mandatory for you to employ a data protection officer. However, I must say that if you don't look at appointing a data protection officer and you hold large amounts of data, it would be an incorrect decision to make. The data protection officer, underneath that individual, would have the data processors and data controllers. Within your organizations, it should be seen as a senior role. The reason being is that the fines that are levied on a breach are huge, and therefore it should have and hold enough clout and weight to ensure that it has the ability to make change where necessary. So when I talk about seniority, I talk at C-level, and I talk at board level. Now, looking at the fines and looking at what's happened in the past and the concept of that will never happen to me, well, APTA, last week, 42,000 records. I'll come on to some others. And I've met with a lot of companies in the last 6 months that it will never happen to, funnily enough, and they're not really going to do much about it. But I assure you, the ICO has already gone to the central government to ask for more funding for resources for May next year. And the ICO's opinion and point as to how they will treat this is that they're not really interested in the top FTSE 250 companies, because those people and individuals and companies have the money to spend in order to get themselves into a position where they will be compliant. The ICO will be looking for companies on the next rung down and the next rung below that, because those are the ones that are being very complacent about how they treat this piece of legislation. And again, it's a one-stop shop, so this is about citizens' rights. Any citizen at any time can report any company to the ICO, and the ICO are obliged to investigate that breach. Okay, I'm running a bit over time, so I'll speed up. So there are 5 key principles that are followed. The first is lawful protection of data, and that is how data is processed in a legal and lawful manner. The second, data can only be collected or used for an explicit event or an event in time. So if you're doing a campaign, you can use the information as long as you have permission to do what you need to do with that information. Once you have completed the campaign, there is no need for you to retain that information, so it needs to be removed. And you need to put in processes and procedures to ensure, again, that you have a trail to demonstrate it has been removed. The data that you're using must be adequate, so you can't overuse information. You only use the data you need for what you need it for. You can't use, I don't know, the colour of my skin for a campaign that talks about shampoo, for example. So it is specifically the information you need for the campaign that you're doing it for. It must be accurate, complete, and up to date. At any one time, I can say to any of you, the data's incorrect. You must correct it. This is what you need to put in, and you have to correct it. You cannot be complacent about taking the information and forgetting about it, because if it's found to be inaccurate, and I find that it's been used inaccurately, again, I have grounds to report you to the ICO. Again, it goes back to keeping all individuals or people that are being subjected to a campaign or their data is being used. Again, they must be identified for processing purposes. If you can't identify them, you can't use the data. And the data must be, I don't need to really spell that out, it must be processed in a secure manner. These are the 6 key principles that form the backbone of GDPR. If you are building GDPR against these principles, then you are on the right track to becoming compliant. So accountability and governance. This is an interesting one, and I won't go into all the points on here. Suffice to say that governance and accountability have changed in GDPR. In the Data Protection Act of 1998, a lot of the processing that you do is not mandatory, and I'll give you some examples of that as we go along. You now need to have appropriate technical measures that ensure that you demonstrate you comply. So anything that you do within the processing, housing, using of information requires documentation, requires a trail that can be auditable. If I'm giving you access to a piece of information, I need to know why you have access to it, what makes you need it. If you don't need it, you don't get access. It's simple. You don't have a blanket access. People have access to what they need, not a blanket access. In the Data Protection Act, current act, that's not a mandatory thing. This is becoming a mandatory thing within GDPR. as I say, you must maintain relevant documentation. It is one of the biggest things that will be ever changed. And please don't just think of computer records. Think of records that sit in filing cabinets, records that sit on your I was going to say floppy disks, that sit on your USB sticks, on your C drives. This is about ensuring that everything is fully documented and secure. We've talked about data protection officer. And these are the measures. So you keep your data use to a minimum. You use what you need to use, and you don't overuse it. There is a complete transparency around how that data is being used and processed. You can allow individuals to monitor that processing. So if I want you to tell me what you're doing with my information, you have an obligation to tell me that. And it's this whole thing, GDPR is an ongoing thing, so please do not think that after May the 25th, you can put your pens down. This is a piece of statute or legislation that will evolve and evolve, and the purpose of your data protection officer is to ensure that you are always relevant, you are always up to date, and you are always carrying out the proper audits that you should be carrying out with your processes within your own business, and doing the training that's necessary on a constant basis to ensure that your staff are complying with the legislation. So here's a new thing. So under the Data Protection Act of 1998, data impact assessments were not mandatory. They are now, or they will be. So if you are going through a transformation in your business where you are implementing new services, new software, new processes and procedures, you have to carry out one of these. And this is a risk assessment. It's no different to carrying out a risk assessment of putting in some software. But you have to have full documentation around that. You have to plan it into your project, plan it into the transformation that's happening now. Because if you don't do it now, you're going to have to do it again when GDPR comes into legislation. So if you are working on these types of projects, then this is now a mandatory thing. You have to do this. Detailed by design and detailed by default, also mandatory. So again, when you're planning and designing your systems, you have to think about data flow, security of that data flow, who has access to that data, why they're going to have access to it, what they're going to be doing with it, how are you going to delete it, what trail have you got to show it's been deleted, what archives are you keeping. This is mandatory. This was not mandatory in the current Data Protection Act. And again, as I said, the data controller has a huge responsibility. That individual sits below your data manager, but data protection officer. But if you don't employ one, your controller will be your point person that will be responsible for maintaining those 6 principles and for maintaining data within the company. Also, the data protection officer, which I've not put up here, but which I will mention, needs to be independent. They cannot be a CTO. They can't be a cybersecurity expert. They have to be an independent that sits outside that business. They are business focused. They have legislation that they have to manage and comply with. Cybersecurity is a part of that, but they aren't a cybersecurity expert. They are a data protection expert. It's a very different thing. So, some fun, some breaches. I won't go through them all, but we all know about TalkTalk last year, so they were fined almost $500,000 for a major breach. There's just a few. I'm sure you're aware of some of these. Here are some statistics, and I don't really go with statistics because they vary. As soon as I put this up, it's out of date, but hey-ho. It just gives you an idea by sector of incidents that have happened over the last couple of years. I'm going well over now, so I'm going to speed up. And these are the incidents. Interestingly, loss of paperwork sits at the top. And so some interesting stuff. These were some of the breaches that happened, have happened in the UK. And as I say, I think you're getting a copy of these slides, so you can read that at your leisure. The most interesting one was Sony, which was the biggest in the history at the time it happened, which was 77 million records of Sony PlayStation users, my son included. Morrison's was the biggest in the UK. Thanks. I've gone well over, so thank you for listening.